Thank you. Very good morning, everyone. Can I have my slides, please? Okay, can we zoom in? Yeah, so while waiting for the slide to be zoomed in, thank you very much. I'm going to talk about the Constitutional Court's 6 basic principles. So this is Indonesia, and what we see here in the red is severe water stress, including the island of Bali, where we are now. During drought season, we have a severe water stress. So red are severe water stress, which occurs during dry season. And below there, as we can see, the Indonesian water productivity is very low. It's on the circle below. And you can see again there that the island of Java only have 5.9% of water, but we have 56.5% of water. So almost all of the islands of Java is in the red, which means severe, or in the yellow, which means high water stress. And these are some of the examples of water conflict which I collected. As I said, this is only an example. There are some conflicts almost everywhere, in Borneo also, but I have not mapped them, and also in Papua, including in Bali. There are 3 at least which I look at in the news of conflicts. So we used to have a water law, but then the water law was judicially reviewed, I think, several times, and the water law was finally invalidated by the court. And so the court states that in terms of water commercialization, we will have to pay attention to these 6 basic principles, something to deal with state control, fulfillment of human rights, environmental conservation, and then state control again. And then the 5th, that the priority has to be given to state-owned enterprises or region-owned enterprise. And finally, if water is still available, the government may grant permits to private enterprise to commercialize water based on strict requirement. Number 5 is interesting. I think number 5 comes up because of resource nationalism and state capitalism, which is a tendency of Indonesia. So the court tends to interpret state control through state-owned enterprises. It seems to be the trend in natural resources disputes. So I would like to talk about the strengths now. The first is that the strengths is it reinforces the duty to protect and respect in terms of the human right to water. It reinforces the duty to fulfill. It highlights the importance of environmental conservation. And then it states the manifestation of control by the state through state-owned enterprise. So these are the strengths. Other than human rights to water and environmental protection, it offers guidance and allocation. So how should we allocate water when there is a stress? Which one are the priorities? And so the House of Representatives then implement the 6 basic principles here into the allocation framework. What we have here on the top is the minimal daily basic needs, but interestingly, we can see there that state-owned enterprise is under rank number 8, and water utilization for the private sector, individual enterprises, is under principle 6. So this means actually that small, medium enterprises or individuals who are in small, medium enterprises, or they have something commercializing water, they sit on the bottom rung of the allocation ladder. And people's farming, which is actually very, very water intensive for rice field irrigation, sits on number 4. So these are the manifestation of the Constitutional 6 basic principle. But we don't have explicit environmental flow in the allocation framework. So the wording is only taken into account. So now I would like to talk about the limitation. The first is that I think the 6 basic principle is not sufficiently broad. So it is supposed to be basic, but I don't think it's basic enough in order to settle water dispute. The 6 basic principle only deals with allocation. So allocation is when we have too little water. But water dispute can occur not only because water is too little, but also when water is too dirty or when water is too much, which is flood, as you can see. So we have pollution, for example, which I don't think the 6 basic principle can handle. And also we have questions of our water services. Is concession or divestiture or private sector participation allowed or not? Is it not really clear from the 6 basic principles? So these are the limitations. And also the court says that this is the principle for the commercialization of water. But it doesn't say that this is the principle for the governance of water. I think this is also limiting because it presupposes that non-commercial water use is okay, but actually no. Non-commercial water use, even if they are used by farmers through boreholes and groundwater, it can destroy the environment. And this is very important and probably could be related to the earlier presentation from Professor Partain. The 6 basic principle neglects efficiency. So if we look, for example, in the integrated water resources management, we have 3 values. The first is equity, second is environmental sustainability, and the third is efficiency. And we can see that there are different kinds of water footprint there. For growing beef, for example, it requires a lot of water. So it is much more efficient to grow, for example, to use water for the production of bottled water because it requires very less, 1.5 is the water footprint, than for growing meat, for example, or for other kind of uses. But this is no longer possible if we interpret the 6 basic principle in a textual way. So, thank you. There are these are the example in which conflicts over water quantity occurs and the principle is not applicable. For example, what if there is a conflict between farmers and farmers? The principle is not applicable because it doesn't say anything what happens, who should get the rights to water. If there are conflicts between smallholder farmers and industry, the principle is applicable, then the smallholder farmers should be prioritized first. But it is dubious if there is a conflict between rice field and aquaculture. So, for example, there is a conflict between rice and aquaculture visited by one of the ministers. It's dubious how it should be applied. If there is a conflict between a smallholder versus drinking water. Now, this is happening actually in Bali, in which we have a subak, and subak is a UNESCO heritage culture, and much of the water has been taken by the drinking water utilities or the industry. So the water that we are using for taking a bath is probably coming from this traditional irrigation system called the subak. So according to the 6 basic principle, drinking water should be prioritized because it's a part of human rights. But it's actually tricky because drinking water utilities also supply hotels or apartments or convention centers such as this, which is actually commercial. So the principle is applicable, but it doesn't provide the solution. The 4, if we have a water quality conflicts, for example, between hydropowers and floating net cages, this occurs in dam, for example. The principle is also not applicable. I mean, who should win? We don't know how the rights should be allocated. Also, when we have aquaculture versus rice farmers, it is dubious. Also, when we have conflict between aquaculture versus tourism, it is not obvious who should win. Also, we have special conflicts with water implications. So, for example, somebody cut down the forest and then it reduces the water flow. We cannot use this principle. And what happens if there is mining dewatering versus drinking water? It's not really applicable to. And we have here a customary water tenure in the Kahayan catchment. So they have this called manuba using poison. It's just part of culture. And they have lanting houses. This is located in the island of Borneo. So this is a kind of customary water tenure. And they have the handil and the beje, which is also a customary water tenure, but not necessarily customary law. And there often overlaps with palm oil plantations. And also, now we have a food estate project in the island of Borneo. So we cannot use this principle. I don't think the principles are applicable in these cases. So my conclusion is, first, the principles can only be used to guide some allocation conflict, but not water conflicts, but not the broader water conflicts, such as conflict arising out of privatization and concession. Secondly, the principle, by literal interpretation, covers only commercialization, but not water governance. And thirdly, the principle, although it incorporates equity and environmental sustainability as values, it neglects efficiency. And the fourth, which is, I think, could be quite dangerous, is that the principle may prohibit the reallocation of water to higher value uses. So as I said earlier, rice field takes a lot of water. Sometimes you have to opt. Are we going to choose rice field or hydropower or blackout? So if we choose the rice field, then we're going to have a blackout. But actually, hydropower has a lot of welfare maximization function, which is lower if it compares to a rice field. So my recommendation is as follows. The first, we have a literal and teleological interpretation. I think we should interpret the principle teleologically, which I suggest that the water should be exploited to the greatest benefit of the people's welfare, so welfare maximization. And also states that less than economically optimal, but nonetheless equal allocation of water would violate the Constitution. So what I'm saying is, if the allocation of water does not maximize welfare, it violates the Constitution, because the preamble of the Constitution said that the foundation of the state, why we establish the states, one of the purpose is to maximize people's welfare. So we use the teleological interpretation instead of the literal ones. And the second one, I think we could expand the scope of the principle from commercialization to governance. And finally, we should set up reallocation framework in the legislation. So the teleological interpretation, which enables efficiency as value guidance, the government should then set up a reallocation framework based on equity and environmental sustainability principles. So for example, we can build irrigation systems so that they can be more efficient for the farmers, or we can give the farmers water storages so that they can harvest rainwater, or we can have monetary compensation if we have that. But we cannot have it if we interpret the principles literally, so only restricting the private sector as very much at the below rank of the allocation ladder. So finally, this is my presentation, and I welcome very much your suggestions, because I'm working a lot with the FIO, with the World Bank, and with the Ministry of Public Works, which is currently setting up the implementing regulations of the water law based on the 6 basic principles. Thank you very much.
Thank you so much. Thank you so much, Mr. Mova. Our first respondent would be Mr. Max Stewart, PhD. The time is yours.
Thank you very much, Chair, and thank you for the presentation. I'm no expert on water law, nor on Indonesia or on Asia, so I approach this paper more as a generalist reader, but I'm very pleased that I was assigned as a respondent, because I think that this is really an important contribution in demonstrating more broadly how constitutional courts are central institutions for addressing third-generation fundamental rights. In recent years, I'm hearing from other colleagues who are experts on the Global South that courts from the Global South have taken up a leading role in challenging the view that judiciaries overstep their competencies when adjudicating second and third generation rights. And I think Dr. Mofa's paper succeeds in demonstrating how questions of water allocation, quality, and managerial efficiency are a source of societal conflict and prompts questions on addressing them via judicial interpretation. The paper furthermore presents, I think, an internationally relevant example of the interaction between constitutional courts and legislatures, since as it explains, the legislature in Indonesia reacted to the decision of the Constitutional Court that had introduced the 6 principles for managing water conflicts. So with its ambition to provide advice to the court, it utilizes a standard interpretive method where specialists in a particular area of law, in this case water law, reach out to the judges, who usually embrace a need to keep a more general perspective in mind. So I think in this sense the paper is very helpful also for legal practice. So Dr. Mofa recommends to adopt a teleological reading of these 6 principles and subsequent legislation that would enable the principles to consider a wider set of water conflicts which are not covered by the currently prevailing interpretation. And I think the demonstration of this conclusion was very convincing. I wonder, however, whether the teleological reading does not set too high of a bar on the possibility to measure efficiency as contributing to the overall welfare of the population. So I wonder whether this resembles somehow a utilitarian reading of welfare, that by allocating some water to industry, taxation incomes may increase and this would benefit all. The question here would then be, however, that more income through taxation is no guarantee for welfare improvement on its own without robust democracy and accountability mechanisms for the exercise of state power. So I wonder, and this could be also a question, so how the Constitutional Court to effectively revise the emphasis on prohibition of commercialization that you convincingly demonstrated needs to embed its water conflict jurisprudence in a broader reading of requirements for entrepreneurship as well as exercise of state power in a democratic regime. And in the last couple of minutes, just 2 more questions to this fascinating analysis. So one, I think it would be interesting to hear more on the factors or motivations that might have driven the Indonesian court's decision on these 6 principles, as this could also offer an insight into whether and how the alternative proposal that Dr. Mofa suggests is a potentially feasible one to be embraced by the court in the future. And the second question pertains to this distinction between the inter and intrastate water conflicts that you highlight, and as discussed also yesterday in this conference, we are primarily discussing conflicts within the state, and I completely agree that it is important to focus on these types of conflicts. I wonder whether your recommendations actually for allowing commercialization of water supplies when this benefits the society as a whole could also be applicable to interstate water conflicts, or to what extent then interstate water conflicts require a different set of considerations to be accounted for in constitutional court decision-making, should such a future case arise in Indonesia or elsewhere. So overall, I think this is a very promising work that I just look forward to see published in a very near future. Thank you very much.
Thank you very much. Thank you very much for first respondent. And our second respondent would be Ms. Titis Andiani from Constitutional Court. The time is yours.
Thank you. Firstly, I would like to appreciate Mr. Mofa's paper because it is mainly well written and brought up an interesting issue regarding the restriction on water tenure rights based on Constitutional Court Decision Number 83 of 2013. However, I would like to know why or on what basis you feel the need to mention the limitation principles numerically as 6 basic principles, particularly on the title. Probably you could just mention basic principles without using the exact figures or the figure 6. You still could, of course, elaborate further in the analysis discussion that the limiting principle consists of 6 or 5 plus 1. You already mentioned in your paper that it is called 5 plus 1 because the limitation principle given by the Constitutional Court consists of 5. Then, if the five principles have been fulfilled, the following principle states that the government may grant a license to a private business to exercise control over water under certain conditions. But that is probably not necessary to put the number 6 in the title. In the introduction, Mr. Mova very well described the facts in the field and how water scarcity became the forerunner of conflicts over water management rights in Indonesia. However, I was wondering why Mr. Mova did not describe the actual background of the court's decision. In this case, the petition for judicial review that transpires the Constitutional Court decision number 83 of 2013. In fact, the legal consideration in a Constitutional Court decision are statements or responses of the Constitutional Court to the constitutional issues raised in the case. Therefore, I think it is very relevant if the background part of the paper is elaborated again with the petition submitted by the petitioner, because without the petition, there would be no decision. Then, in the conclusion, Mr. Mova provides an efficient solution on how the court needs to expand the interpretation of the 6 basic principles into water governance as a whole instead of only water commercialization, or even need to be given a theological interpretation to reach the prosperity of society. It makes me want to know more if the Constitutional Court has to do this in the future. Probably Mr. Mova has analyzed or estimated which laws that have the potential to be used as an object of review that can be used by the court to respond in its decision with more suitable interpretation as recommended by Mr. Mova. Then maybe as a suggestion, Mr. Mova probably can explain the scope and limitation of the Constitutional Court's authority in deciding judicial review cases, because I think the courts can only create constitutional interpretation of an issue only if the issue is petitioned by the applicant in the case of judicial review. And the court itself cannot create cases or issues decision without petition. Okay, thank you.
Thank you so much. Now I open questions from participants, one from the my left side and one from the right side. From the left side, Professor Roy, and from the right side? Okay, Professor Roy. Yes.
All right, thank you so much. And I had a PhD student who recently also engaged with the water laws of Indonesia. And so I have a little bit of background, not your expertise, but I was stunned when my student got into the water laws of Indonesia. They're in so many different parts of Indonesia's regulatory world. Some in the agriculture, some of the water provisions, some in the water regulatory authority provisions, and they're all over the place. There's also some adat out there, traditional community rules. One thought I have as the kind of scholar I do is there's so many pieces and parts. How can one support a court to be tracking the whole of this very fractured and scattered water regulatory system to ensure that it is on constitutional principles and on human rights principles? And is there a way forward for Indonesia to maybe unify its water law systems, or is there a way for there to be, like in the United States, maybe a restatement of the water law, so it's not the actual law, but it holds it all together in one place so that the court can interact with it to better ensure constitutional harmony? Because there's so much of a historical evolution of these many water laws that we were just stunned, the complexity of it. And so that in essence is my question. Is there a way to make it easier for judges to ensure constitutional goals are achieved?
Okay, I think there's no more question, and you can respond on that, Mr. Mova. Thank you.
Thank you very much indeed for the comments. I think it's going to be very, very helpful for my article, but also for the application in the upcoming legislation. I think first one is from Max. Does it set the bar too high? Yeah, I don't know. Could be, because through this article we are expecting two. The first is the Constitutional Court to reinterpret, and then the second question given by the second respondent. But also, we are asking the government to do some theological interpretation, which I think they would be rather hesitant to do it, because they don't want to violate, so to speak, the literal interpretation given by the Constitutional Court. As the second question is, what are factors and motivation, and why the principle? Yeah, I think the two factors, I think, is a combination between state capitalism and resource nationalism. State capitalism here means that the state-owned enterprise is being regarded as an entity which should safeguard state control over the natural resources in Indonesia. This is the case in the oil and gas, this is the case in the electricity, and this is the case also in mining sector. So a lot of priorities are given to the state-owned enterprise. But water is a different kind, it's a different thing. I think it's really, really different. I mean, it's different from oil and gas. Someone can just bore a hole and then can get some water. So it's different principles should apply. Regarding the interstate water conflict, yeah, I think the interstate water conflict usually occurs in a federal state, like in the United States and Australia. I have no exact expertise on that, but I think the similar principle could actually should apply. We cannot lock, as Professor Roy said earlier, we cannot lock the parties, assign the rights, and exclude them from negotiating. We have to open it. So if it is more welfare enhancing, welfare maximizing for the industry to compensate the farmers, for example, that it should be allowed. The question on what basis do I mention the 6 basic principles? Yeah, it's because it's been highly regarded as 6 basic principles, but I would consider it again. Thank you very much. So I just say it's actually 5 plus 1. So thank you very much for the suggestion. Also, thank you. I will try to describe the background of the case. And there was a question regarding how can we adopt this by the court. So which I think one of the way is we can try to ask another judicial review of the existing water law legislation and try to persuade the court to reinterpret that because the existing legislation encapsulated the court decision, and then it specifically says that the private sector should be at the bottom rung when if water is still available and it can go to them. So we can judicial review that article and then offer this my paper probably as a solution to that. And lastly, commenting on Professor Roy, yeah, I think it's very difficult with water because we have forestry on one hand, we have agriculture, we have fishery, we have natural conservation and mining, and they are all related. So what we have in Indonesia for now is a framework law, actually. The water law is a framework law. I don't know how we can make it simpler, but probably the 3 principles offered by integrated water resources management of efficiency, equity, and environmental consideration can help. But in terms of consolidating them into one single legislation, I think it's going to be probably, if not difficult, then it's probably impossible because simply water is just everywhere in plants, in our drinks and services, in the pipes, and yeah, so it's very complicated. Thank you.
Thank you so much. We have now come to the end of the second session as we begin at 8:20 and we finish at 9:20. Now let us give applause to the speakers and respondents. Thank you so much. And further questions and discussion can be conducted after the lunch or after the session or outside the forum. I will give time to the Master of Ceremony, Mary. The time is yours again.